Thank you very much, Ignacio. Good morning, good afternoon, or good evening, depending on where you find yourselves. On behalf of the American Association of Private International Law, it's a pleasure and an honor for me to be here participating in this activity. And I would like to congratulate you on the magnificent organization and the speakers for their relevant interventions. And at the same time, I celebrate the synergy that year after year is consolidated between the HCCH and aSADIP, where the HCCH Regional Office for Latin America and the Caribbean plays a transcendental role. Without prejudice to the richness of the subjects and the various topics that have been addressed previously, I would just like to share a number of brief comments with you. Firstly, importance of the dispute settlement system from the point of view of international strategy for companies and individuals. There are a number of obvious facts that cannot go unnoticed by anyone. On the one hand, increasing internationalization, and then on the other hand, the increasing complexity of these cases as well, which require legal solutions to reflect that reality. And thirdly, there's the question of procedural and cooperative issues of private international law, which are at center stage. Although it's well known, what's said by Professor Moreno, that a large part of disputes in commercial private international law cases are resolved via arbitration, I think it's essential to understand the effects that a choice of court agreement can have on the development of disputes discussed before the courts, especially in Latin American and Caribbean countries. In this context of contemporary international relations shaped by current economic and political processes, we mustn't lose sight of the fact that in this region, trade and international business and investment are increasing rapidly. This is a time when we see that we need to have agile, clear, and flexible laws in place, which are essential values in international trade in these countries. The analysis of choice of court agreements is an issue of vast dimensions. We need to have secure and predictable rules in place, because a choice of court agreement, as we said, as the previous speakers have said, plays an essential role with regard to predictability. And the achievement of the 2005 convention is not irrelevant for international commercial traffic, as it can reduce the economic risk of litigation, hypothetically, which might take place in more than one jurisdiction, but in many countries, in different times as well. And it needs to be effective. And that requires a number of aspects to be taken into account: respect for the clauses. So the way in which the 2005 convention is written offers technical and legal certainty to these questions. And despite the fact it can't cover all of the areas, but it does provide a number of procedural instruments which are there to allow people to choose a court. This legal cooperation requires an international legal system in place, which secures the legal certainty for the different parties with regard to their operations, and also which recognizes or which regulates recognition of these agreements. As a third point that I would like us to consider, we have to think about the role of party autonomy as a criterion for the attribution of jurisdiction. As was said by the Secretary General at the beginning, with its restrictions and nuances, it's clear that there is a universal tendency to admit the autonomy of will in just jurisdictional matters. However, the jurisdictional landscape in certain areas in Latin America and the Caribbean can appear a real labyrinth with existential problems. The determination of the criteria for jurisdiction is not uniform. There is no specific international convention on jurisdiction for the Americas, all of the Americas overall, and the instruments and criteria for cooperation and the recognition of enforcement of judgments can be different too. And as the professor from Paris said, there's also the Bustamante Code. And there are also differences when it comes to legislation in different countries in a region. We also have to think about another important reason, which might be particularly relevant in our countries. Given the tendency to apply lex fori to many international cases, choice of court clauses offer insurance against forum shopping. And in a legally fragmented world, the parties do not have absolute certainty ex ante as to the jurisdiction that will settle the dispute. Hence, party autonomy allows the parties to significantly reduce this uncertainty, as two professors previously referred to. And the Buenos Aires Convention is also one to take into account. It's the client that decides. The parties decide on the agreement. And finally, as a final point, I would just like us to take into account a retrospective view as well as a prospective view of the convention in Latin America. From a general perspective of the situation in Latin America, as Professor Hardy and also Ignacio pointed out as well, Mexico is the only country that has acceded to the convention to date. In 2005, at the time of the birth of the convention, the only autonomous private international law legislation in Latin America was the Venezuelan Private International Law Act of 1998, which enshrined the autonomy of the will as a criterion for attributing jurisdiction in property-related cases. Things have changed in recent years. There's the Dominican Republic Private International Law Act of 2014, as well as the Panamanian Code of Private International Law, Civil and Commercial Code of Argentina from 2015, and the recent Uruguayan General Private International Law Act of 2020 enshrined the autonomy of the will as a criterion for attributing jurisdiction in international commercial transactions, obviously with certain limitations, as do draft private international laws of Colombia and Chile. By this, I mean that Latin America, in its autonomous private international law legislation, has taken a step towards expressly enshrining party autonomy in jurisdictional matters in international transactions. Perhaps this will allow us to have a more auspicious forward-looking vision of the Hague Convention. This prospective vision implies in identifying trends, opportunities, risks, costs, and benefits, and based on a critical, serious, and reflective analysis, actions and policies can be adopted in our countries in the coming years. It's not insignificant that Brazil and Paraguay are studying the instrument with a view to its ratification. Within countries with civil law traditions, where there are sources of international private law as well, it's very auspicious that all are working in the same direction. However, there are enormous challenges facing the region, and we have to try to ensure that there is a trade-off between flexibility and legal certainty. So now more than ever, what we need to have clear rules of the game, because ultimately signals sent to the market are more necessary than ever. In this respect, striking the right balance between having clear rules on the choice of court is not merely a possibility, but in recent times, it's become a real requirement. And ultimately, today's event has been given the name Bridged 2021, Innovation in Transnational Legislation, and the symbol is a connecting bridge. However, a bridge does not stand on one side only. It's not enough just to have the 2005 instrument. Perhaps innovation in the field of transnational litigation today requires a thorough analysis, first and foremost, by our countries to assess the effective viability and subsequent implementation, without losing sight of the fact that the choice of court agreement, with all that it implies, also carries within it the most modern idea of accessing justice as being a fundamental human right. This analysis should not remain unfinished business for countries in the region in Latin America, and the Academy, as well as the states that have private international law advisory commissions in the ministries of foreign affairs, can collaborate and be real agents for mobilizing the changes that are deemed necessary. This conference undoubtedly has been a bridge to cross and to bring together various issues, but also from an academic and judicial point of view. And it's been extremely rich. So I would like to conclude by saying thank you very much for taking part actively. I would like to congratulate the HCCH. And of course, we are committed to continuing to collaborate actively with the Regional Office for Latin America and the Caribbean on this and so many other issues that we have in common. Thank you very much indeed.
Thank you very much, Paul. I see some clapping. Those were absolutely perfect closing remarks. We are very grateful to you personally, but also to ASADIP institutionally for your continuous support to the work of the regional office, of the Permanent Bureau, and for years to come. Many thanks to you all for your presence, for your engagement today. Many questions, many could not be addressed during the sessions. This was the 2021 edition of the HCCH, the Bridged, and it is a bridged besides the bridge, because it wishes to introduce briefly and pragmatically these topics to nurture your interest to further study and promote these conventions. And I hope we have met that objective. Final note to recall that the recording of this event will soon be available in our website. And in the meantime, I wish you a good balance of the day and hope that you will join us for future editions of the HCCH aBridged. Stay safe, and that's a wrap. Thank you very much.